just to see how we're doing on the participants front. We're up into the 60s and growing, so I think we will start off. As I said, my name is Paul Wilkinson. It's my pleasure to be hosting today's webinar, which is sponsored by Mail Manager. Our topic today is digital risk, and for the next 50 minutes or so, we'll be looking at the role of technologies in mitigating, managing and resolving disputes. And whilst on the subject of technology, as you can probably see, we are using the Zoom platform, and we will be showing our panelists and our discussion areas as we move forward. Audience members are muted, but you will be able to submit questions using the chat feature, which you'll find on the bar on the screen in front of you. We will be monitoring this during the webinar and allowing time for some answers at the end. I think at this stage also it might be useful if your question is for a particular person, perhaps please add their name with your question. Anyway, so our panelists today are from a range of organisations, and indeed partly also international. We have May Winfield, who is Associate Director at Borough Happold Engineering. We have Graham Brown joining us from Toronto, who is a partner at Cassels. Here in London, we have Rob Horn, partner, Head of Construction and Engineering Disputes and Risk at Osborne Clarke, and Vicky Reynolds, Head of Digital at i3PT and Cert Central. So we will be moving through an agenda here, looking at the current dispute landscape, why are disputes happening, what makes, in inverted commas, a good case, a good dispute, and then looking to the future, trying to establish maybe what are the practical steps we can take to avoid disputes in our businesses and in our project lives. So let's start by asking what sort of disputes are happening now. So May, perhaps I can start with asking you the question first. Can you quickly outline what types of dispute you are currently hearing most about?
I'd say at the moment, it would come as no surprise that a lot of the disputes one notices in sort of the legal press and just hearing about are COVID-19 related or disagreements. It's force majeure, having to suspend works due to people not being around or people not being able to get to site if it's international. And as a result, you then have delay, time and cost overrun. But on a more general basis, I think over the last few years, the thing that is the biggest source of dispute, and you'll find this in the Arcadis annual disputes report, is people not complying with the contract. So where people aren't serving the right notices, people aren't complying with the contractual obligations. And I say sometimes that's because the obligations are quite vague and the understanding may be different. And you'll find that with, say, BIM, where someone may be asked to achieve level 2 BIM. Well, what does that actually mean? But it's not specific to that area, but just as a general thing. And I noticed the last 2 or 3 Arcadis reports, it hasn't actually changed, that the big disputes are simply compliance with the contract.
Okay. Graham, is May's overview similar to what you see in Canada?
I'd say it's quite similar. We've seen pretty sort of steady disputes over the last couple of years in the usual areas, whether it's unpaid extras or simply just non-payment, lien disputes and that sort of thing. But with COVID, I think it's been a slightly different situation here. Particularly in my jurisdiction, the government shut down sites for a period of time, but not very long compared to other businesses. And so there's been a really interesting stratification of how the different COVID disputes are set up. Some of the sites were able to stay open all the way through there was no shutdown. And so the argument coming from those sites is, well, we couldn't have as many people on site, or the work cost more, or we have to pay more for safety protocols. And obviously there are significant contractual disputes around that. You know, is that something that was already included in your contract? Is that something that you should have contemplated ahead of time? And of course, all of that, whether the site was shut down or not, that ties into a force majeure argument, which May touched on. But there's also other provisions in our contracts here that you commonly see related to changes in law or stop work orders, and people are trying those on for size as well. So just as May said, it often does come back to whether proper notice was given, whether or not this is something that is expressly covered by the contract, whether it can be implied in the contract. And so that's really where the COVID disputes are heading. Interestingly, we've also seen an uptick in procurement disputes, which I think in part is probably due to the fact that as budgets tighten and as revenues potentially slip in the near term, or there's a bit of a loss of opportunity due to sort of extended conditions, I think people are a little bit more edgy about procurement and looking to enforce their rights a little bit more. So we've definitely seen an uptick due to COVID, but at the same time, pretty steady on the usual disputes front.
Yeah, and Rob, from your point of view, are your clients, starting to tighten the screws a little bit with some of their projects, or is the changes yet to percolate through?
I think to a large extent is yet to percolate through, and I suppose I have a slightly different view to May in whether the force majeure COVID-19 issues are turning into disputes yet. I think at the moment, from my perspective, most of the issues are being dealt with reasonably sensibly. You can see this backlog of problems on projects that's going to work its way through, where projects have shut down, as Graham was saying, in Canada, or where claims have been made but are yet to be resolved. Now, whether you formally call those disputes or not, I think is questionable. But if you put those in a slightly different category and then look at the potential for a second spike in COVID-19 force majeure issues, new projects that are coming online which have and will have a different reaction to COVID-19. Now, we've got legislation in place that talks about how you work in a lockdown environment. Actually, force majeure won't apply in the same way in those cases anymore. So I think it's going to get a lot more complicated whether you look at the sort of short-term COVID-19 force majeure type issues, but how they then start interacting with the more underlying typical delay, disruption, loss and expense type claims that haven't gone away, and I think at the moment have just been suppressed because they're not as business critical as COVID-19, getting people on site, getting some work done, and that's whether you're a contractor or an employer.
Yeah, I think while you're on, Rob, perhaps we can maybe just start raising the technology issues, the digital aspects of this. What technologies are typically being deployed during projects that have a bearing on disputes in your experience?
I mean, I think it's really interesting, not only for May to be a panelist, but May's already sort of introduced this issue of can you clear the first hurdle of properly defining what your digital or technology solution to anything is. And I think the majority of people that I talk to at the moment are still falling at hurdle number one. They've got these great ideas of the technology they want to use. Are they properly incorporating it so it helps them at the end of the day in a commercial or dispute sense? I think the answer to that is generally no. But the sorts of things we're seeing, BIM is the obvious one, but there's lots of other things out there as well, whether it's something as simple as the massive increase in digital photography, which we mustn't forget about that. Enormous amount of data that you can gain through everyone on a site having access to a smartphone that just takes pictures and fires them into a central server. That's a massive change. Up to drone imagery, automatic tracking of supplies. I mean, these are all things that are live at the moment. The integration, I think, is the piece that is missing or is the next evolutionary step forward. So how do you integrate all these different technologies. So you get the BIM model talking properly to the electronic program, that talks to the procurement tools, that talks to the payment mechanisms. Once you've done that, then you'll start to see all of the benefits that come out of the technology. But at the moment, we're seeing lots of disparate technology in lots of different areas using different formats that don't necessarily talk to each other in a very cohesive way. And I think that's a real danger looking forwards to what's going to happen over the next 2, 3, 4 years, as you've got projects that are running and using this technology, which helps the construction process, but might actually hinder the commercial process.
Yeah, this might be a good point to bring Vicky in. Vicky, perhaps you can just briefly explain what i3PT does as an organisation, and maybe then we could start talking about the digital processes and making sure that people follow those correctly.
Yeah, absolutely. So there are actually 2 streams to i3PT. We have our services side of the business and a software side of the business. And the business itself grew from BCAR legislation in Ireland and a need really to evidence better quality management on construction projects. And that is a legislation that actually in quite a lot of ways mirrors the draft building safety bill. And the requirements that are likely to be released in that as well over the coming months. So the way that we work is we have certifiers and inspectors on site that certify and inspect work at every stage of the planning, design, and construction. In fact, that we were collecting a lot of data and information with nowhere to put it, that could analyze it, assign responsibility, create appropriate workflows for that evidence-based then storage of data and information. So Cert Central, which is our software side of the business, was then formed. And basically we use Uniclass 2015 classifications to link data and information to work packages, and you can see essentially for an element or a drawing or an area of works, all of the inspections that have tests that have taken place, passes and fails there, who undertook them, whether the issue was rectified, who it was rectified by, and once rectified, who checked that work and signed it off. And if it's not good enough, it then goes back round to the beginning of the loop. And you can start to see then, by the time you get to the operational phase of a building, all of the history of your asset. And and I think it's really important that when we talk about technology, we really, really embed the idea of good data and information management there, because a lot of the technology that we need to deliver these projects exists in other industries, and all we need to do to implement them is to better understand the way that we link that data, that information, the way that we create open information in a secure manner, basically the right people having the right time, the right information at the right time to make the right decisions. And everything has to solve a problem as well. And there's no point implementing technology just for the sake of implementing tech if it's not solving a problem for you.
Okay. No, I think you quite neatly explained a little bit about Rob's point about integration of technology and BIM, for example, and process. We were just about to launch into just the final point on the screen, which is the importance of insurance. I think, Vicky was making the point about the value of information, and I would expect insurance businesses are looking for the power of that information to help them understand the risks that they are insuring against. Is that something perhaps that Rob, you might want to come in?
Sorry, I remember to take myself off mute. Yes. So I think the insurance industry, believe it or not, is probably even worse at using technology than the construction industry, despite the fact that all of the underwriting is really data driven. So little of it that I see actually gets into the nuts and bolts of the documentation and information that is available to it, rather looking at historic data of what insurance they've issued before, and therefore using that to forecast what the insurance market should look like in the future. When you're in a very rapidly changing market, which I think we are or are just starting to get into, I think that just needs to change. I think the other thing, and the other thing that's important around insurance at the moment is the last point on that slide, where margins, and it might be interesting for Graham's perspective as well, but where margins in the UK for construction businesses sit at 1% or below, every construction business is on the brink of insolvency always. And it takes so little to push them over the edge into insolvency. And we've seen that recently, even with big names like Carillion. So it doesn't matter how big a company you are, you still get caught by insolvency if you're not running your business properly on these tight margins. Where you're a building owner or developer, particularly if you're a smaller developer, so non-governmental, the insolvency of a contractor or some supplier that further down the chain can be absolutely critical to not just the project, but your survival. So you see one supplier taking down whole supply chains through insolvency. And the idea should be that insurance can step in and fill that gap and retain and enable projects to complete. I don't think insurance is doing that at the moment. Insurance is still too wedded to sitting behind professionals rather than constructors, and trying to get that shift over to construction will be easier when the insurers identify and start using the technology and the data that's out there in order for them to properly forecast risk.
And there was a prompt there, I think, for Graham perhaps to come in with a perspective on what was happening in Canada.
I don't disagree with anything Rob said. I don't know if I would say here we quite have the same sort of precarious nature for all contractors and suppliers, but certainly we've had some big insolvencies recently, and obviously with everything that's gone on this year, there are predictions that there will be more in the future. And here the big thing is, are you going to be able to call on a bond? So we have a surety bonding process. I assume it's quite similar to the UK. And people are looking to call on performance bonds if there's a contractor insolvency, or if there's a non-payment, they may be looking to call on a labor and material payment bond. And similar to what Rob said, it's not always the case that the surety will step in as expected. And if there is a case for an insurer to step in on behalf of an architect or an engineer, again, they'll typically represent them, but it's not guaranteed that you will have a response. What's been interesting recently is that we've introduced new legislation in my jurisdiction in Ontario recently, guided at prompt payment and adjudication primarily, but behind the flashy prompt payment and adjudication introduction, which obviously the UK has been dealing with for years, but we're very excited about here since it's brand new, has been mandatory public bonding on projects of a certain size. And so putting those mandatory bonds in place is intended to create a little bit more safety for some of those situations on public projects. But whether or not it does anything other than sort of increase the amount that gets paid to sureties remains to be seen.
Do you mind if I make a quick comment, Paul? Is that all right?
Please.
Just on insurance there, I mean, insurance companies a lot of the time as well are reliant on data around actual problems rather than risk. So all these insurance companies hear about are the issues that have got so big that they can't be hidden or swept under the carpet, you know, the ones that have gone into litigation. And that's where, I know I keep harping back on about it, but things like uniclass classification or classification in general, and having clients in control and developers in control of their own information and data across the construction projects as well. Because what you tend to find is that at the end of a construction project, the contractor will hand over the information that they're comfortable with the client seeing. So even if you wanted to do any analysis on risk or anything like that, you only get a very blinkered perception of the reality. And so for insurance companies to properly start looking at where the risks are in construction projects, they have to have accessible data about risks in construction projects, which means we have to get rid of this feeling that we shouldn't be sharing lessons, and that it's a failure if we have a risk. Basically all of the collaboration and open working that we're pushing for digital and data, we need to be pushing as an industry in terms of communication and culture as well.
Cool. I think that takes us on.
Go ahead.
May, go on, May, you were going to say.
Yeah, no, just one comment about that, because I worked in construction, the insurance industry for some years. And one thing I would say, I completely agree with Vicky, but I think the difficulty of that is currently the insurance model for, say, PI is claims made. So we are limited to some extent as to what we can disclose, i.e. as an industry, to each other, to avoid invalidating your policy. And that's where things like, say, integrated project insurance comes in, new insurance models. But also in terms of sharing information, clear documentation would help.
Mm-hmm. Yeah, I think that we were going to move on to a section on why are disputes happening, and I was going to put this to you and to Vicky. Really, is why is the construction industry so litigious? Is it down to this lack of openness, this unease about sharing information?
Yeah, I think there's a lot there to do with culture. And when we talk about culture, I think people often miscategorize that as behavior. People's individual behavior is often formed by the culture of the industry. So a really good example is I was working with a legal representative for a main contractor not so long ago, and was trying to essentially sell the concept that they should be integrating BIM into their process at the earliest possible stage, regardless of whether they receive that type of information, because it highlights to them issues with design at an earlier stage. And his response to me was, well, I don't want to know about the issues, because if I know about them, I'm responsible for them. If I can not know about them until the point where I procure my subcontractors, it's then their problem. And first of all, that level of passing on risk doesn't exist. That's not a real world thing. You can't do that. But the really important thing to note there is that guy's not a bad guy. He's not a bad lawyer. He's just been formed by the experience that he's had in the industry. And if you ask someone individually whether that's right or wrong, they'll always say it's wrong. But if you ask them in the context of their organization with that responsibility on their shoulders, you get a different response, because you have to protect yourself. And I think one of the things that we really need to look at is how we change that culture. Is that through a change in procurement methods and contracts, or something else?
So, May, can we contractually obligate people to be collaborative, or are there other more pressing mindset issues that we need to overcome?
I think you can, and I've always suggested people do this, and there's a couple of ways of doing that. For example, saying you have to meet, or virtually at the moment, and talk to each other once a month. And that sounds really silly, that you have to tell people to do it, or you have to exchange information every 2 weeks, and this is the information you have to share. And over time, from my experience over the years, you force people to collaborate and talk to each other, and they realize actually it's a better way of being, and then they do it naturally. But you certainly, if you don't put, say, in the contract, yes, you have to talk to each other once a month, then people may or may not. So it's building into the process. And the more clarity people have, the more willing they will be to collaborate. If your contracts are very vague as to who's responsible for what, people are going to be a bit hesitant. Whereas if it's clear what people's roles are, they will know how much they should share with you. If they share additional information, it's very clear in the contract, you can't rely on it. They are just sharing it, so you're aware. Things like that, just making all the who's and whys apparent.
There's an element of risk for the individual and the organization as well. If it's deemed more of a risk to hide information than it is to share information, then that's where we want to be. Whereas if it feels like, yeah, it's not the right thing to do, but I'm at less risk of being found out, or having something dropped on my shoulders, then people are going to carry on acting the way that they are. So Grenfell's a great example of that. It really has highlighted to the industry that no matter how much you think you've passed on that contractual responsibility, you will still get hammered if your building falls down or sets on fire if you are the developer, the client, or the contractor in that scenario. So you can't just close your eyes and say, that's someone else's problem now.
Paul, do you mind if I jump in here?
Yeah, sure.
Just first of all, I think we might need to flip to the next slide to start with here. But in terms of, I think those points that were made are excellent. And in terms of the culture and human behavior, I mean, we're dealing with an industry where you have a pyramid of contracts where people who are at the bottom of the pyramid don't have privity of contract with people who are at the top of the construction pyramid. And so that always creates stress because you're supplying services and materials potentially to a project for somebody else's benefit without the ability to claim against them directly and without an ability to communicate with them directly. And so inevitably, there's a two-way stream. One way is, am I getting paid? And the other way is there proper performance? And so when you have that kind of a relationship, it's critical, obviously, that you not only have a good system of contracts, which unfortunately in this industry, perhaps just due to historical behaviors, isn't necessarily always the case. And when you don't have a clearly defined contract or your contract doesn't sort of have proper buy-in from the on-site team, so you've got a team who's either bidding tenders or preparing sole source contracts that aren't necessarily then downloaded to your on-site team so they can behave according to that contract, then problems arise. And so that's why having some sort of smart contract system, or at least investing more in the front end, and I'm speaking against my own interest here as a litigator, but investing more in the front end of your project inevitably helps in terms of performance. And then once you get into that contract and into that project, and you've had your team buy in, you've had them look at what are the notice provisions of this contract, what do we have to do to properly perform here, putting the technology in place to maintain documents is absolutely critical. Because when you do come to the point, whether it's for an adjudication or a long-term dispute, those documents are critical. And I have a client who likes to say, he who has the most documents wins. Well, that's not necessarily true, but certainly I'd rather be in the position of the party that has details about the contractual notice that was provided or details about that extra that was actually approved on site than be in the position of the party who's trying to respond to that and doesn't actually know what happened. So certainly being able to properly create and retain documents and then find them quickly is critical to avoiding disputes as time goes on. And so I think there's a little bit of culture there. I think people are more used to sort of, unfortunately, picking up a dispute than spending more time on the front end. And obviously, whenever you do have an opportunity, if you have an RFP as opposed to a tender or some sort of informal procurement that allows you to negotiate, people are often more focused on getting shovels in the ground than getting the perfect contract. And so, you know, again, I always pitch that if you can spend a little bit more time on the front end, you can avoid the dispute on the back end, and it's certainly less expensive.
Rob, do you want to come in on the role of technology, perhaps does more technology make disputes more or less likely? And if a dispute does arise, does it make them more or less easy to resolve?
Yeah, before I answer that, I'm just going to go a step back because I think it's an important bit of context because I have a slightly different view to all of the other panelists on contractualizing collaboration. I think you can't do it. I think all you can do is encourage and set a framework that enables and encourages collaboration. As soon as you step beyond the creation of that backdrop and the ability and the tools to collaborate and try and enforce collaboration, it falls apart because it runs directly opposed to what it is you're trying to actually create. If you only have a collaboration because the contract says you have to, that collaboration, in my experience, will fail. You need to address the cultural piece, and I think that's relevant when you start looking at technology, because technology doesn't have a culture, save what you may have put into the technology through some subconscious bias as you're writing the programming for it. So when you strip out the culture and you're just left with a machine which reads data and reaches results in a very mechanical fashion, you end up with some very odd results sometimes, which aren't necessarily helpful. So I think you have two different places you can go with your question, Paul, around does technology create more disputes or reduce them? First of all, you can have a different set of disputes around the operation of the technology itself. Did the technology do what it was supposed to do? So I think that's one area, and I think that's relatively obvious, that you can have, if a piece of software doesn't work, you can have a dispute about whether it worked as it was intended or not, and whose responsibility that might be, and what problems arise as a consequence. So that's one issue, that technology creates a whole new subset of disputes. But actually, when you start importing technology and getting the technology to take any form of the decision making rather than just being purely processed, so enabling humans to do what they do a little bit more easily, if you hand over any of that decision making to the machines, you can end up with a whole new set of problems where you get the unexpected consequences of the way the contract works. So if you ask two people to read a term in a contract, they might both come to the same conclusion, but a machine or a lawyer, and then not necessarily the same thing, might come to a completely different conclusion. And that doesn't mean the lawyer/machine conclusion is the right conclusion. It just means it's a different conclusion, perhaps, than either of the parties ever intended in writing the contract. So again, coming back to this creation of additional disputes through technology, if you're not really careful about how you incorporate, use, and hand over potentially control to technology, you can start creating additional disputes, not just about the technology, but about things that you didn't realize were problems until someone has pointed it out to you. And I think, for anyone on this webinar who's been unfortunate enough to deal with dispute lawyers, you will know we're pretty picky, and we go through and tell you all the things that you've done wrong, and all the things that everyone's done wrong, and all the ways your contract doesn't work, in order to try and get you to a range of different solutions. When you do that with a machine, rather than it taking an amount of time and an interface with a human and explaining what you're trying to achieve, the machine just spits out an answer. That can be really difficult to deal with, because there's no emotional release from understanding why your case doesn't work or why you've got this problem when it's a problem you didn't anticipate. So not only do I think you can have additional disputes created through technology, but I think you can have much more difficult to resolve disputes created by technology, because the way people think, the way dispute resolvers think at the moment, doesn't necessarily match with the way data will be produced or computer decision making takes place. So I think we are in a very interesting and exciting time frame in terms of how you manage digital risk, because there are so many unknowns at the moment that it's very difficult to predict what's going to be happening in 3-5 years' time.
Yeah, technology
Thank
has
you
to
very
be a
much, Rob.
enabler for better behaviour. Yeah.
Just move on, if I may, because I think we are going to find ourselves squeezed for time unless we move forward on this, assuming I can move forward on the slides. The makings of a good case. I think May, you're about to come in there, but perhaps you could, if you're going to respond to Rob, then follow on with this question. What components make for a good dispute or a good case? Is there such a thing as a good dispute?
I think the first thing to bear in mind is how few things actually get to formal dispute in the construction industry. And when I say formal, I'm thinking arbitration, court case adjudication, most things very rightly get settled of the parties sitting around a table, possibly with the lawyers involved. And so what you need at different stages varies slightly. However, what helps you in terms of making your case to the other side, so you don't spend years and millions of pounds trying to prove that you're right, is having the right records. So you can say, well, this happened at this stage and we agreed this. I've, over the last 17 years of being a construction lawyer, I've seen so many instances where clients have said, well, I'm sure we talked about this 5 years ago and this was agreed, but I just have to find the email or the meeting note or whatever it is, and then spends 2 months trying to look for that. It's also having the right mindset, to be honest. Anyone who's been in more than one dispute would have encountered people who just dig the heels in and do not really want to openly negotiate. And you have to appreciate no one really wins in a dispute. It's what works best for both sides. And probably the clients will know that more than the lawyers. The lawyers can advise you, this is your legal position and these are your possibilities of success. But due to who's involved and the sort of project you may want to settle or may want a different arrangement. So I think those are in some ways the main components, but looking on a wider basis, using the right technology to compile both your records over the course of a project, but as soon as you have a dispute, using the right technology and using the right tools to compile what you need to put together evidence. And that's not just records like emails, that's also things like using, say, a 4D model. I've seen instances where in adjudications, in informal discussions, and certainly heard about several occasions where a party shown a 4D model to explain where the critical path was, where things started to go wrong. And it was far easier for both the other side, but also the adjudicator or the mediator to understand where they were coming from. And those sorts of things can be really powerful, particularly, say, with a judge who isn't necessarily isn't going to be necessarily a construction person. They are very experienced in construction law, but seeing it visually makes it far more compelling.
Yeah, this 4D here is showing the schedule, the process, the time lapse of a sequence of activities.
That's right.
May has talked about the importance of records there, Graham. And it reiterates the theme that you mentioned earlier, that documents are a critical factor in disputes. Has the rise of digital technology changed your experiences in delivering cases in Canada in the same way that May talked about?
Well, yes and no. I think from a lawyer's perspective, lawyers are much more commonly using digital collection techniques from clients, and we're able to use what we call e-discovery, which is sort of our own document management system for presenting cases. And so if we are provided with the right documents by our clients, then certainly we can present the case in a more efficient manner. And sort of like Rob said earlier, when a dispute's delivered to a lawyer's desk, we're going to be picky, we're going to be asking questions, we're going to be pointing out what you did wrong, and we're going to be identifying risk. And May's absolutely right. Many cases will never progress past the early stages if the documents are there. But I think what's missing still is on the front end, on the client end. What are our clients using right now to make sure that they're building a record? And I don't think there's any sort of standard, at least in my jurisdiction, as to what people are doing. And so I often speak about the importance of documents, because ultimately, if I'm going to meet with you later and talk to you about a dispute, I'd like you to have those documents top of mind. In the absence of a critical email, you may not be able to prove that you gave contractual notice. You may not be able to prove that you're within a limitation period. And again, in my jurisdiction, we're just introducing adjudication, something that the UK has been dealing with for a while. But the big discussion here is, with the timelines in our statute, when you only have 5 days to respond to an adjudication notice, how are you going to do that if you don't know where the documents are? Or as May sort of alluded to earlier, if somebody's left the company and they were the key project manager, how are you going to get their emails? How are you going to find the banker's box of documents that they've filled up and left in the corner of their office and know that that's where your critical document is? So I do think, at least where I am, I'd like to see more uptake on records management and records production on the front end as well. So whether it's using more digital drawings and maintaining them, whether it's making sure that you have native formats of schedules so that proper scheduling analysis can be performed by experts, or whether it's just implementing procedures for your organization. And so when I say that, I mean, once you've got the contract, the in-house team sits down with the on-site team and says, look, here are the critical deadlines that we're going to have, both statutory and contractual. And here's how we're going to make sure that we not only meet those deadlines, but we paper our trail. And when you have that and you have a central place to file those documents, then not only are you going to be ready for that 5-day response to an adjudication notice, you're going to be able to put together your paper package, but you're also going to be in a situation where if you end up in an early project mediation, or you end up getting served with a statement of claim or whatever it is, you're in a position to just pull the document you want very quickly, put it on the table and say, are we really going to do this? Or is there a better resolution to be had on a business basis? I think the other factor in all of this that gets ignored is staff sanity. I think that when you get to the point of a dispute and you ask somebody to stop doing what they're doing on site and go pull a bunch of documents and nobody knows where they are, you drive people crazy, and you frustrate them because they've got another job to be doing, and now they're trying to find documents or recreate history, and that's problematic, not only for the dispute side of things, but also for the internal staff management side of things.
I think Graham's alluded there, obviously, to having audit trails, supporting the discovery process. Rob, has this been a challenge in with any of the clients that you've dealt with who've entered into disputes over what has happened in the past?
Yeah, I think it's continual, and actually, I think I have a slightly different problem to Graham. I don't have a problem with the documents that are being created. Generally, what I find now with clients is they're pretty good at documenting what they have and haven't done, and the decision making and what happened on projects. The problem I have now is just the volume of it that's being produced. So it's not unusual for me, even on a relatively modest case, and by that I mean, so let's say it's around £10 million in dispute. So not an enormous case, but not tiny either. But a £10 million dispute can easily generate 1 million documents. There is no physical way anyone can sit down and read 1 million documents in any sensible way in order to work out what really happened on the project. If you haven't managed the documents, if you haven't set the documents up properly so they're being recorded, tracked, using the right keywords, you actually create an enormous problem for yourself later on. And I think, as we go forwards, that's where you'll see a lot of your lawyer cost being spent. It's all around trying to track down the documents. Not that they don't exist, they do exist. It's just you can't find them anymore. And you have, particularly in adjudication, so welcome to this, Graham, particularly in adjudication, you get enormous data dumps of information where you just get sent through a stick drive with 200 gigabytes of information and just answer that in 5 days. It's logistically impossible unless you're properly geared up to be able to decipher and manage that data at those sorts of quantities.
Vicky, perhaps we can just also briefly follow on from what Rob's just talked about in terms of data. I think some of the issue comes down to how that data is structured. Some of it might be semi-structured, some of it will be unstructured. Can you sort of briefly explain the differences between the different types of data and why it's important to manage both?
Yeah, of course. I mean, and I just want to clarify as well that we've mentioned documents a lot. We don't mean documents, we mean the information within them, because I've seen projects that have all of the right documents, but actually the stuff within them is crap. You've ticked all the boxes and you've put all those documents in the right places, but in terms of the real world and the real project you're working on, it's useless. So it's the information and data within that, and to find the relevant parts of the information, we have to have that structured data so that things become searchable and findable. So for instance, unstructured data is just your Word document. You think it, you write it, that's it, you're done. If someone else wants to decipher that, they have to either borrow your brain, understand the way you think, or read the document word for word with a highlighter. And that's probably what I imagine a lot of law work is like. Then you've got the more you structure the data, that really just means formalizing what you call things, finding key classifications. So agreeing that you will ideally follow an industry classification system, because that can be picked up with technology and platforms. But a worst case scenario, it should just be something that's common throughout your project. So if you call this element this over here, you call that same element by the same name everywhere else when you reference it. So then if you need to find information about that element, it's like Google, you would type it in somewhere and all of the references to that can come up. Or if you want to take it to a much more simpler step, you open up your Word document and you do a word search, and it's there. So yeah, I think formalizing data in that way is critical, and that has to go all the way back to planning and design as well. The earlier on in a project that you can specify your language, the more commonality you have throughout it, and the stronger your data and information becomes. And what you put in place during the planning stage can ultimately help you no end in operations or during construction if there's any kind of dispute or anything like that. And just a little bit on formalizing communication as well, using common data environments, document management systems for RFIs and things like that. Our system does that, and seeing the difference in the way that people email each other about something versus when they know it's in a system where it can be tracked. The type of communication is very different, but it can be exactly the same question and exactly the same thing that they're communicating about. So anything that formalizes a process a little bit more, standardizes it, it makes people stop and think, okay, this is important. And that then feeds back into the cultural piece.
So it sounds a bit like some of the practical steps we need to take to avoid disputes in the future, which I was going to ask May about. I know May suddenly dropped out and dropped back in again. I've had that experience myself this afternoon as well. What can companies do to get their house in order to avoid disputes arising at some later point in a project?
I say two of the main things. Firstly, get your records in order. As Rob alluded to, I've had experience too of having to go through hundreds of documents trying to piece what the agreement was. And it's a matter of who's working on the project, making sure they keep all their records and emails in a central system. They're not keeping them locally, for example. You're naming your files in the correct way. You have a proper internal process. So if there is a problem, you can pull up the correct information, the correct data to work out what the issue is. The second one is to get your contracts clear. How many times still in this industry we all start work before we have a signed contract, before we have anything in writing as to what we're doing, how much we're doing it for, what's the extent of our liability. Or if we have a contract, it still says, can you do a bit of this? And it's quite vague as to what we're responsible for, how long we're responsible, who else is potentially liable as well. And I think one of the things, if people are using, say, more advanced technology in their project, don't expect your lawyers to understand. That's not necessarily their role. They're relying on you to explain to them what the processes are that you use, what the risks are, so they can build into your contract the relevant protections, clarity, limitations, if that's appropriate. And in some ways, it's going back to the basic question of understanding, if you had a dispute tomorrow, would you be able to explain to your boss who did what, when, and how, and who's responsible for it? And if you can't do that, what do you need to do to resolve that? What sort of information do you need to keep? Who, if people are leaving, making sure you compile their information before they leave. Over in various previous organizations I've worked for, I've seen people leave and then it's, oh, where's their computer? Oh, oops, it got wiped. Okay, we've lost 2 months worth of their emails. Oh, where's their phone? Oh God, that got wiped as well. And it's just, again, it's realizing data can be put in different places, and not appreciate, you can tell people till the cows come home that they should keep things in a centralized system, but they may not. And what you can do to just allow for, say, human error.
Yeah, I think the one common suggestion is that successful collaboration is 90% people and process, and only 10% technology in this process. Rob, is that a balance that you think the future is going to maintain, or is technology going to become more important in that equation?
I think it's a really interesting question, and it's one that I think gets an awful lot of airtime, and probably quite unnecessarily, because everyone's just guessing. We all have this sort of dystopian vision of massive machines going around digging up plots of land and magically creating buildings all over the place with no human involvement at all. To the extent that ever happens, that's well beyond my working lifetime. I think what we'll see is a progression and an integration of technology into the process management and the ensuring and checking and cross-checking what we do on projects. But I think another important point, and it's something that Vicky may have sort of touched on, is the importance of utilizing the data. It's no good just gathering the data and dealing with the problem that you can see right in front of you, or dealing with the problem that happened 6 months ago and is now a dispute. Actually, what you want to do is to be able to grab that data and look forwards into the future and say, as a business, how do I use that experience to make sure I don't end up there again? So when we talk about the future technology and our disputes going to be technology-led or people-led, I think the power of the machine is in the analysis of that data to produce information to enable humans to make decisions about how they want to continue to act in the future. So all the technology can do is present options, and all it should do, for me at least, and without being too technophobe here, but all it should do is produce the options and say, well, okay, here's what you could do, here's how you could operate, what do you want to do? If you take option A, the consequence is you make lots more money. If you take option B, you make less money, but you have less risk. If you take option C, you'll probably lose money, because it's a stupid thing to do. Once you can utilize the technology to enable you to make informed business decisions, that is a really powerful tool. And that comes, as we've spoken about several times, it's the integration of all of these different bits of information gathering or data production tools that we've got to funnel all of that into a sensible reporting tool that enables business decisions to be made.
Yeah, I think I have already seen prototypes of platforms which take data from project delivery processes and make some kind of predictions about the outcomes. But these are still at a relatively early stage in their development. One thing which has been published is the Building Safety Bill, and I know that Vicky spoke about this earlier. It brings forward this requirement from Dame Judith Hackett's step forward. Perhaps Vicky, you just want to expand on that, why it's important?
You cut out a little bit there. Sorry, could you repeat the last part of what you just said? I'll crack on and I'll give a little explanation of the bill, and hopefully
golden thread of information means yeah.
Cool, awesome. All right, so yeah, the Building Safety Bill, a draft version of that has been released for public scrutiny at the moment, and it is closely linked to Dame Judith Hackett's Building a Safer Future report, which was in response to the Grenfell disaster. In that report, Judith Hackett mentions a really strong need for better information management, robust record keeping, and making sure that the right people have the right information to make better decisions. What is really interesting actually is, although the golden thread played a huge part in the Building a Safer Future report, it's actually not in the legislation itself at the moment. And there are many, many reasons for that. But there's a lot of talk at the moment about how we define a golden thread. Is it a list of requirements? Is it a concept? And so the Building Safety Bill focuses more on ensuring that the gateways that we have in construction projects are hold points where we check information about security, we check quality of what's happened to date before we pass on to the next project team. So there are gateways at the end of planning, at the end of design, and at the end of construction. And the really interesting thing here is that once you've finished a construction project, you can hand that over to your client. If it's over 6 stories, then it's relevant to the Building Safety Bill, which means if you can't confirm that you followed all of the proper safety requirements, and that confirmation will be embedded in the concept of a golden thread, because you have to show that you have the right information. It has to be searchable, and show that you can make that information available to the tenants who might need it, the fire safety representatives, all as and when they want that data. If you can't show that, then nobody can move into or live in your building. So that puts a really, really important onus on the client, the developer. That role, they become the accountable person for that process, which takes us back to passing on risk and feeling like you're not responsible and accountable. This bill actually puts that responsibility firmly in the lap of the person who will be benefiting from the running of that building. So that's sort of a summary. I hope that covers.
Great. No, that's been really helpful, Vicky. I'm conscious that we're now at 5 o'clock has just passed. It might be opportune if we have any questions, perhaps to look at what's come through, if anything. So, I mean, there's a lot of, obviously there were some issues about me moving on PowerPoint slides and things of that kind. I had a question, perhaps one for Graham, just to pick up on maybe the final point, the future. You know, it sounds from some of the things you talked about in terms of adjudication, in terms of prompt payment, that Canada is following practice in the UK. Are there any areas where perhaps Canada is wanting to push a little bit further forward and might be setting an example for the rest of the world to follow?
Wow, interesting question. Well, I think that for the most part, I mean, we're looking at very similar things. So the integrated project delivery model, which looks at using technology and efficiency in construction to have everybody sort of work together and use big rooms and things like that to deliver projects more efficiently and with more broad-based risk is a really interesting thing that's being discussed a lot, although I don't know if that's unique to us. I think that's something that's going on around the world. And also smart contracts. I think that's something that a lot of people are looking to implement, which has a lot of promise for a lot of the things I've been talking about already in terms of making sure that everybody on your team understands the contract and knows where to find things in the contract and can implement strategies for risk management more effectively. I think, you know, there's no magic to the kinds of things that companies can be doing to push things forward in a more efficient manner and manage their risk better. I mean, I saw one of the questions that came in was how good are businesses at being able to access and collate the information needed in a dispute? And the reality is that in the construction industry, they're just not good. And May and Rob and Vicky have all done a great job of talking about why that's not good. And I have no problem telling most of my clients, you're just not doing the right things. And so Vicky's totally right. It's not just about the documents, it's about the information in them. And so if you have a change order that inadvertently leaves the issue of an extension of the schedule blank because somebody doesn't know that they have to fill that out or doesn't know what the contract says, you've got a problem. You've got a problem for your later delay claim, either for your company or against your company. And so I think what a lot of people are looking at now is, first of all, how do I get my team to fall in line with the contract? What technologies can we use on that front? And then again, what are we going to do to make sure that we're ready? And so as we look at this daunting for us future of adjudication, one of the things that we need to be able to be ready for, and I think that we're talking to our clients a lot about, is how are you going to make sure that you can quickly put your hands on the information you need? And that's what everybody on this call has been talking about so far. And so I think as we look at that and people can implement technologies to do that, that's going to be really important.
I mean, there was a question there posted, in fact, targeted at you. In your experience, how good are organizations at being able to access and collate the information needed in the event of a dispute? Perhaps you can give your answer and then Rob can follow on from his own perspective.
Yeah, well, what Rob said earlier is absolutely right. I mean, I remember as a junior lawyer being one of the people that had to go through those millions of documents, and the stuff you find in there, it's a dog's breakfast. I mean, some of the stuff has nothing to do with the project. I vividly remember going through a series of critical emails to the project, and one of the emails was a screenshot from The Simpsons where everybody's sort of circling around with a rainbow and it said, "Imagine a world without lawyers." And as fun as that was to find, it had nothing to do with the other critical emails in that folder. And so when you do have a 1 million document data dump, not only is it going to be expensive to get in there and find those key documents because you weren't able to find them yourself, but there's the potential for embarrassing stuff in there. And not only that, I mean, aside from what might be embarrassing, there's the potential for documents that you didn't know exist. And so the number of times I've had a dispute start where senior management thinks they have a great handle on what this dispute is about, only to find out that somebody who's left the company or somebody who they didn't even know was involved in either a contract drafting process or a scheduling process had said something unauthorized that ends up binding them. It happens all the time. And then you've spent how much on that dispute just to find out that you have no case. And the perfect example of that is a case I had years ago where somebody wrote something on a schedule and that ended up being the linchpin to the dispute. Somebody wrote something on the baseline schedule that was incorporated in the contract. Nobody authorized them to do it, but they wrote it and it was put in the contract, and ultimately the arbitrator focused on that. So you can't be too careful, and I think streamlining those processes, again, businesses just aren't good at that, and that's where improvement will save a lot of money and make a lot of money.
Rob, over to you, just maybe for some last thoughts on that whole process, being able to access and collate information needed, maybe some time after practical completion and handover.
Yeah, no, sure. So with apologies to all of our participants, businesses are hopeless from a lawyer's perspective at managing data, absolutely hopeless. So I had a client come to me within the last 2 weeks saying they had a dispute under a contract. Could I help them with it? I spent about half an hour looking at it and said, you haven't even got a contract. So all this other stuff that you've been doing, you have no contract in place. So I'll only charge you for half an hour's worth of my advice, but you need to go away and rethink your whole business strategy because you're in a really bad place. If you can't even get that bit right, what hope do you have? And I have to say, even the most sophisticated clients that I've worked with, and you know, I've worked with some very big international players, very hit and miss, and it is very individual driven. So forget corporate policy. It's what does your project manager or project director think, and what does he do on your individual project, and that will define how well you capture data on any particular project. There's such a big scope for trying to standardize and manage that and just make it better. It's really not rocket science, but I suspect Graham would agree with me that when you're reading through those reams of emails, you can spot almost to the day the point at which lawyers became involved behind the scenes, because the tenor and way emails are drafted is just different. In the same way, I would never try and do any structural drawings. I do get upset when structural engineers and quantity surveyors try to write legal notices because they have the same sorts of deficiencies. I can draw a straight line if I get a straight edge. That doesn't mean I know what I'm doing. And it's really important to make sure you understand what the end game is before you start creating documents.
Absolutely. Start with the end in mind, I think is the message there. I think we will have to call this webinar to a close. If there are any other unanswered questions, we will endeavour to answer them offline and perhaps circulate in an email after this event. It's my pleasant task to thank our panellists, May Winfield from Borough Happold Engineering, Graham Brown from Cassels in Toronto, Rob Horn from Osborne Clark, Vicky Reynolds from i3PT and Certificate Central, Cert Central. I'd like to thank the Mail Manager team for organising and hosting the webinar and providing our technical backup. And I'd like to apologise for the technical difficulties we've experienced a little bit, particularly from my side, which I think has been a bandwidth issue locally. My name is Paul Wilkinson. Thank you for listening and goodbye.